Hi again, everybody, and thanks for staying tuned in to the Jamie Meloni Real Estate Show here on 1250 Wins WHNZ. You'll find my show on every Mondays at noon, so I invite you to please tune in as my show aims to become your information source for the Tampa Bay real estate market. Off air, you can find me at my new updated website, tampabayradio.com. Again, tampabayradio.com. And to all the potential home sellers in the Tampa Bay marketplace, I offer a free home valuation if you would text the word value to my cell phone, 813-760-8516. Again, 813-760-8516. Again, text the word value to that number, and I offer you a free home valuation to any of the listeners in the Tampa Bay real estate market. Going ahead and go into our second segment here. I've got Hunter Norton. He is an attorney with Shumaker, Loop, and Kendrick in the Sarasota, Florida area, and focuses his practice on business, construction, and civil litigation. Prior to his legal career, Hunter was a non-commissioned officer in the United States Air Force, where he worked with advanced intelligence and reported to high-level officials. Later, he worked with a private company as a project manager responsible for the analysis of communication systems and authored detailed intelligence training manuals. Both of these experiences have given Hunter the tools necessary to effectively represent his clients with litigation and dispute resolution. Hunter, a graduate with highest honors of the Airman Leadership School in Fort George G. Meade, Maryland, has received numerous awards in his legal career and is with us today to talk all about tax certificates, tenant law, evictions, and HOA disputes. Hunter, welcome to the show.
Thank you, Jamie. I appreciate you having me on.
Thank you very much. Hunter, you have an impressive background that has led to your successes in the legal industry. How has your experience in the United States Air Force with intelligence handling better equipped you for dispute resolution now as an attorney?
Well, it's a good question, Jamie. I tell you, during my military career, one of the biggest things that I could learn was my adversary's weaknesses, but also my adversary's strengths. And that same protocol, I use it daily in my legal career. I'm primarily a litigator. You have to know that the other side is going to say something. They're going to have a response to your argument. And knowing, or at least anticipating as best you can what the other side is going to say, is how you're best going to be prepared going into a courtroom so that you can properly respond to that argument. You know, you don't want to be caught blindsided.
Absolutely.
And that's what I try and do, is anticipate what's going to happen and not ever be caught flat-footed or blindsided.
Now, Hunter, at the end of this month, the property taxes owed for 2013 become delinquent and go up for sale at the tax certificate sale/auction. Explain to the audience how tax lien certificates work.
Sure. It's a unique system. Basically what happens is taxes are actually liens on your property. They're imposed by the county in which the property, where the property is located. So, for example, for your Tampa audience, that would be Hillsborough County. The taxes right now we're paying, or should have paid by now, your 2013 taxes. Those taxes, even though you didn't get your tax bill until probably October or November of 2013, those taxes were actually a lien against your property effective January 1st of 2013. You then pay those taxes on or before April of 2014, the following year. If you do not pay your taxes, then what happens is to get paid for the taxes, the county sells a tax certificate at an auction. And the way that works is kind of inverse to the way you would normally think of an auction. When we think of an auction normally, we think that we're going to go and we're going to gradually bid up to our maximum price. Well, on a tax certificate, the price is set. The county says, okay, $2,000 are owed in taxes for this particular property. What the county then does is allow bidders to come in, and what the bidders do is they bid at an interest rate starting at 18% and then bidding down, such that the person or the entity who is willing to accept the lowest interest rate on that tax certificate is the bidder who will ultimately be successful. So it's an interesting concept, because what happens is the county is going to say, all right, there are $2,000 in back taxes owed. Then you, Jamie, you might say, okay, well, I'll pay the $2,000 and my money will earn interest at 18%. Then I come in and I say, well, I will pay that $2,000, but my money will earn interest at 17%. And there is a bid down, and whoever ultimately bids the lowest interest rate on that amount wins the tax certificate. The county then literally gives a tax certificate, issues it for the property, and that tax certificate is a lien against the property for the next 2 years. And during that 2-year period, the certificate holder, be it you, Jamie, or be it me, or whoever else won that lowest bid, is earning interest on their $2,000 at the interest rate that they bid at and won the certificate at. So their money is earning that interest rate. And what's interesting is that at the end of this 2-year period, if anyone has come in and redeemed, then you, the certificate holder, have earned your money back, the $2,000 you paid, plus the interest that you bid on it, maybe 18%, maybe 10%, but you get paid your interest. If you don't get paid your interest at the end of those 2 years and your principal, then what you can do is you can go into the county and tell the county, I want to redeem my certificate for a tax deed, okay? Now, here's the beauty of the tax deed, Jamie. Mm-hmm. If you get a tax deed on property, it will wipe out almost every other lien attaching to that property, including a mortgage lien. So you're, on the one hand, either going to get back your principal and interest, or on the other hand, you're going to get your property, you're going to become the owner of that property, free and clear of all liens.
Now, but title companies don't insure over a tax deed. They have to go through a quiet title action. Am I correct? Can you explain a little bit more about what a quiet title action is?
Absolutely. Now, what happens is there's a very rigorous statutory and administrative process by which Florida allows for these certificates to be issued and then for the tax deeds to be issued. So title companies are inherently, for lack of a better word, afraid of the process. So they do not want to insure over a tax deed for fear that someone in the chain has messed up the process. Okay. You can account for this in three different ways. The first one, what you just said, is you can do what's called a quiet title action, and I do these all the time for my clients. My client comes in and says, I have a tax deed. What I will do is, under the statutes, there's a very specific way that we go about. We name all of the prior owners of the property back to the date on which the tax deed was issued in what's called a quiet title suit, and I ask the court to quiet title in my client, the tax deed holder, the actual owner of the property. And basically what that is doing is giving the title company the assurance that everything was done properly. The other thing that you can do is title companies, many of whom with whom I work, will, after 4 years, after 4 years have passed from the issuance of the tax deed, as long as there's no one coming out claiming any title or interest in the property, they will then go ahead and write title or insure title for the property. And then the last thing you can do is if the former owner of that property from whom you got the tax deed, if they're willing to give you a quitclaim deed to the property, quitclaiming all of their interest in the property, I find that many title companies will write title in that scenario.
And speak a little bit to the superiority of property taxes. They pretty much trump every other lien. Am I correct?
It's pretty close. Now, if you actually were to open up Florida Statutes Chapter 197 and read through it, you'll see a provision in there, and I'm going off the top of my head, but I think it's 197.522. It says that a tax certificate shall constitute a first lien against all on any property. That's not exactly correct. It's mostly correct, but here's where the exceptions lie. One, it doesn't extinguish any other co-equal liens. So if the state of Florida has other tax liens attaching to the property, those won't be wiped out because they're equal to a tax certificate lien. It also wouldn't wipe out a CDD lien, Community Development District lien, because those are treated the same as tax liens on property. So you wouldn't wipe that out. The only other lien that I am aware of you would not wipe out is if there is a federal judgment or federal tax lien which predates and this is the key part, it has to predate and be perfected before the tax lien attached to the property. Remember when we first began this conversation, I said that the tax lien attached to the property January 1st of the tax year. Mm-hmm. So the taxes that you're paying right now, or if you didn't pay, a certificate is about to be issued on, those were liens on the property as of January 1st, 2013.
Right.
If the federal government came in with a judgment lien and recorded it December 31st, 2012, in the county where the property is located, the tax lien, the tax certificate, would not wipe out that federal judgment lien. But if the federal government came in on January 2nd of 2013, you would wipe them out.
Hunter, it's Stella speaking. I have a question for you around the fact that the tax lien holder has it for 2 years.
Yes.
What happens with the fact that the taxes are due every year?
Okay, so yeah, you're right, because there's going to be overlap.
Right.
So if a tax deed, let's play it out. So if a tax certificate was issued in 2012, right, for taxes in 2011 that came due,
right,
then you're going to chances are the person who didn't pay their property taxes in 2011 also didn't pay in 2012 and also didn't pay in 2013.
Mm-hmm.
Now, so we have a certificate out there dated 2012. We have a certificate out there dated 2013, and we're about to have another certificate dated on that property 2014. If the 2012 certificate holder says, I want to get a tax deed on the property, I want to convert my certificate to a tax deed, that holder of the 2012 certificate goes to the clerk of court in that county and applies for the tax deed. And at the time they apply, that holder of that certificate has to redeem the 2013 and the 2014 certificates. So that 2012 certificate holder has to come out of pocket to pay the principal and interest that was bid on the 2013 and 2014 certificates. You also have to pay an administrative fee to the clerk of court. But once you've paid all of that, then it will go up for tax deed auction.
That's some great information. Hunter, stay on the line here. I got to take a quick break here to hear from our sponsors. If you're just tuning in, you've been listening to the Jamie Meloni Real Estate Show here on 1250 Wins WH&Z. Back in a moment.
Bud Spriggs and Movement Mortgage wants you to experience the thrill of one-day underwriting and the comfort in knowing your loans will be clear to close in record time. While the competition looks to a lost closing date, Bud Spriggs and Movement Mortgage focus on their 12-day clear to close. They do this by utilizing their world-class operations staff to underwrite your loan within 6 hours, process your loan in 12 days, and have your loan closed in time. Underwritten in 6 hours, cleared to close in 12 days. Bud Spriggs and Movement Mortgage. Since opening its doors 120 years ago, Stewart Title Company has established a lasting legacy of providing professional title services. Even other title insurance companies know Stewart Title Company because they do their actual underwriting for them. Stewart is here to provide a wide range of resources to help improve any real estate transaction. To learn more about protecting yourself against hidden title hazards that may threaten your financial investment, call Melissa Stoddard at 813-431-8025. That's 813-431-8025.
Thinking about buying a home? Find out how the HUD Home Store can help you. Visit HUDHomestore.com. Look at HUD homes available for sale near you or nationwide. Why HUD Home Store? HUD will pay up to 3% of the buyer's closing cost. The price of the home is based on an FHA as-is appraisal, which is already completed, saving you an average of $400. And there is an owner-occupant priority bidding period during the first 30 days. Want to know more? Visit HUDHomestore.com.
You're listening to the Jamie Meloni Real Estate Show with local expert Jamie Meloni. Now, here's Jamie.
Hi again, everybody, and thanks for staying tuned in to the Jamie Meloni Real Estate Show here on 1250 Wins WHNZ. You'll find my show on every Mondays at noon, so I invite you to please tune in as my show aims to become your information source for the Tampa Bay real estate market. We've been talking with Hunter Norton. He's an attorney with Shumaker, Loop, and Kendrick here in the second part of the show. And I still got him on the line here. So, Hunter, you and your firm deal a lot with tenant law and evictions in Florida, and the Landlord-Tenant Act governs this relationship. First, what constitutes a valid lease agreement in Florida? And explain to the audience how the eviction process works here in Florida.
Sure, I can do that. Well, first off, what constitutes a valid lease in Florida? It depends on the length of the lease. I think there's a common misperception out there, and I deal with it daily, that if you have just spoken with a landlord and the landlord has orally or verbally given you permission to rent a home or an office space, that you don't have a valid lease, and that's simply incorrect. Oral tenancies in Florida are binding. Now, there is an exception to that. That exception is if the tenancy is going to be longer than 1 year, then it needs to be in writing and witnessed. There needs to be 2 subscribing witness signatures on that lease. So if your tenancy is greater than a year, then it would need to be in writing. But if it's less than a year, it does not need to be in writing.
Okay.
And I also wanted, you said that you were governed by the
landlord-tenant
Florida statutes, landlord-tenant, right,
Mm-hmm.
and that's exactly right. It's Florida Statutes Chapter 83. But I think it's important to know that the landlord and the tenant, in the context of their lease, can agree to different terms that aren't necessarily in the statutes. And let me give you a good example, because you wanted to know what the process was for an actual eviction if you're a landlord. And let's say your tenant hasn't paid you rent, and we're dealing with just a residential home. In that instance, what the statute says is the first thing you have to do is you have to give the tenant notice, a 3-day notice, by posting at the premises or by mailing it to the tenant, which basically says, you haven't paid me rent, here's how much is owed, you have 3 days to pay me. But a landlord and a tenant can agree to a different period of time or to eliminate that period of time. So if in the written lease it says no notice, then you don't need to give any notice. If in the lease it says 10 days notice, then you need to give it 10 days notice. So the lease ultimately controls the landlord-tenant relationship. And after you give that 3-day notice or 10-day notice or no notice, depending on what the lease says, then the process in Florida can move very, very quickly. Because what will happen next is if the landlord gives that notice and the tenant does not pay rent or leave the premises, then the landlord can file an eviction lawsuit. So you go to the courthouse, you file your lawsuit, and here's the really powerful part for a landlord, is that in a typical lawsuit, when I sue someone because you didn't honor your contract or do something else, the other side, the defendant, will need to answer or respond to that complaint in 20 days. But when it's a landlord and tenant situation, the tenant has 5 days to respond to the complaint. So we cut that time from 20 days down to 5 days. Not only that, but for the tenant to come into court and maintain any defenses to the eviction process, the tenant has to deposit into the registry of the court the amount of rent that the landlord says is past due. And if you think about it, that makes perfect sense, because we're already dealing with a situation where a landlord may be dependent on the rent to pay the mortgage, for example. We don't want to extend that period any more than is necessary, which might result in a foreclosure of the property against the landlord. So the Florida legislature and Florida courts have said, we're going to protect the landlord by requiring the tenant to deposit all rents that are alleged to be due and owing into the registry of the court, so that the landlord knows that that money is there when and if he needs it. And the landlord can even ask the court during the pendency of the eviction to disperse those funds to him so that he can pay the mortgage on the property or maintain the property as is necessary. The only exception to that, Jamie, is there is something that is sometimes utilized, but it's not very common. A tenant can file with the court what is called a motion to determine the rent, so that if the landlord put in there, hey, you owe me $5,000 for the past 5 months of rent that you haven't paid me at $1,000 per month, and the tenant says, no, I have only missed 1 month's payment. I only owe you $1,000. The tenant can file with the court what's called a motion to determine rent, and attach to that motion copies of any documents which establish the amount of money that the tenant has paid to the landlord. Then the court will have a hearing on that matter and tell the tenant exactly how much money needs to be deposited into the registry of the court, and then the tenant needs to comply with that if the tenant wants to continue to defend the eviction action. But typically what happens is the tenant does not do that. The court just enters a judgment for possession, because under the statute it says there's not even a need for hearing, for further hearing or notice if the tenant does not deposit that rent into the registry of the court. So the court simply issues you a judgment for possession, and that judgment for possession directs the clerk of court to give you what's called a writ of possession. And that's the key document, because the writ of possession essentially allows the sheriff to put the landlord back into possession of his property. And what happens is the landlord will take from the clerk that writ, deliver it to the sheriff. The sheriff will thereafter contact the tenant by posting that writ at the premises, and the writ says, you have 24 hours to leave, and if you don't leave, the sheriff will remove you from the premises and put the landlord back into possession.
And I think you had mentioned when we talked last, in your experience, you've never seen a tenant actually deposit monies into the court registry. Is that correct in your experience?
That's correct. I mean, I've been doing this for, going on 9 years now, and not once in my experience have I ever seen a tenant actually deposit the rent. I have had tenants who filed motions to determine rent. I've actually gone through hearings where the court has said this is how much is owed. Tenant, you have 24 hours to deposit this into the registry of the court, so I've gone that far in the process. But I've never had a tenant actually deposit the rent. Now, that's not to say that I haven't had tenants, settle with me. I've certainly had tenants pick up the phone and call me and say, hey, can we work something out? And, obviously an amicable resolution, if we can reach it, is always the path that we want to take. We don't want to engage in full-blown litigation if we don't have to. No one wants to go through a full-blown eviction. Mm-hmm. Sometimes it's necessary, but we don't want that. So if we can work something out, we will work something out. So I've had tenants call me, and we've worked those things out before. In fact, I've represented tenants before against landlords, and we've worked things out. But in my experience, I've never actually seen a tenant deposit the rent into the registry of the court. That's very interesting. Well, Hunter, we're running up against the end of the show. You've gotten some great information out to the audience. Real quick before we go off air, give out your contact information for the audience and how you can help them out. Absolutely. I'm based in Sarasota, but Shumaker has offices in both Sarasota and Tampa. My number I can be reached is at 941-366-6660 or hnorton@slk-law.com. Hunter, thank you very much for coming on the show. If to the audience, if you didn't get that information, he'll be up on my website here within a couple of days in the past guest section. But if you want to reach out to him, I highly recommend him. I've known him for a few years, and he's a great attorney here in the Tampa Bay region, specializing down in Sarasota specifically. Hunter, thank you very much for coming on the show. I appreciate you having me, Jamie. Have a great day. All right, you too. If you're just tuning in, you've been listening to the Jamie Meloni Real Estate Show here on 1250 WINS WHNZ. And again, you'll find this show on every Mondays at noon, so I invite you to please tune in as my show aims to become your information source for the Tampa Bay real estate market. On the first half of the show today, we were talking with Michael Meloni. He was a New York State-based appraiser with also ties to the Naples, Florida region. Had a great conversation about real estate in both New York and the Naples area. And we just closed up the interview with Hunter Norton. He's an attorney with Shumaker, Loop, and Kendrick down in the Sarasota region, but that firm represents clients all across the Tampa Bay region. So I invite you to reach out to them for all of your legal needs, especially with regards to eviction and property tax certificates, which is going to be applicable to the time that we're in now as the taxes for 2013 come due as of the end of this month, at which point they will go delinquent. Again, you've been listening to the Jamie Meloni Real Estate Show here on 1250 WINS WHNZ. I invite you off air to my website, tampabayradio.com. Again, tampabayradio.com. And also you can get me by my phone, 813-760-8516.
for all your real estate needs. Thank you all very much for listening to the show, and I'll see you all again next week at noon.
The opinions, viewpoints, and promises made